Hey guys, I'm going to talk to you all about a company based out of Wisconsin called the Orion Energy Systems and how it was involved in a legal case with the Equal Employment Opportunity Commission, or the EEOC. The suit was challenging a wellness program under the Americans with Disabilities Act, and it was alleging that the employer, Orion Energy Systems, retaliated against an employee who objected to the program by terminating her. So they had a wellness program in place. This employee objected to participate in it, so they fired her. Orion instituted this wellness program unlawfully because they required medical examinations and made disability-related inquiries. So you can obviously have a wellness program, but you can't require certain medical examinations, and you cannot make disability-related inquiries. Wendy Schobert was the employee in question here, and she was the one that declined to participate in the program. Orion shifted responsibility for payment of her entire premium for her employee health benefits from them as her employer to Wendy Schobert, their employee. Shortly thereafter, Orion then fired Wendy. This is in violation of the Americans with Disabilities Act, as it was applied to Wendy, and that Orion unlawfully retaliated against Wendy because of her good faith objections to the wellness program. The court found that the wellness plan was lawful because it concluded that the employee's decision whether to participate was voluntary under the law existing prior to the regulations. So the wellness program itself was considered lawful, but their reaction to Wendy objecting to the wellness program and some of its specific questions was not. In the end, Orion agreed to pay over $100,000 to Schobert, or Wendy. The company further agreed that it would maintain any wellness program in the future that poses disability-related inquiries or seeks a medical examination that is not voluntary. Orion also agreed not to engage in any form of retaliation, including threats or interference against any employee because he or she raised objections or concerns as to whether the wellness program complies with the ADA. The company also agreed that it will tell its employees that any concerns about its wellness program should be sent to its HR department. Also, Orion had to agree to train its management and employees on the law against retaliation and interference under the Americans with Disabilities Act. The company had to conduct an additional training meeting with its CEO, its COO, its Chief Financial Officer, its Human Resource Director, and all employees responsible for negotiating or obtaining health benefit coverage or selecting a wellness program. And this training ended up explaining all the provisions of this degree and the requirements of the American Disabilities Act and its regulations as they pertain to wellness programs. So, long story short, one of their employees at Orion Energy Systems objected to participating in their wellness program. They didn't like it. They eventually ended up firing her because of it. This ended up being determined it was against the law. They got in trouble. They had to pay Wendy, their former employee, over $100,000, and then had to go through a bunch of different trainings to ensure that this did not happen for them ever again.